Hi, good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. Today, we have a special treat for you. We have two different lawyers, one in civil litigation and the other in criminal law, and they're going to kind of look at, in the wake of the pandemic, how getting back to business is going to look like. First, we have a criminal defense lawyer, Sia Pashang.
Yes, good evening, and first and foremost, thank you, John Paul, for having me on this Justice and Pieces series, and especially with esteemed counsel, Adrian Nicolini. It's good to see this program that you're operating thrive, especially during the pandemic. And by way of background, I'm a criminal defense lawyer practicing as a sole practitioner, exclusively in the area of criminal defense. Charges varying from theft to murder, and I practice in the chambers. And prior to that, I was in a criminal defense firm. And at this time, I'm happy to share the floor with Adrian.
Let's turn it right over there to you, Mr. Nicolini. There, can maybe tell us a little bit about yourself and your practice?
Yes, thank you very much, John Paul. I too am privileged to be here and appreciate the invite. This is obviously an extraordinarily important topic. Our profession and more so our clients faced a very uncertain period at the beginning of COVID as to whether or not we would be able to engage in our day-to-day activities, whether we'd be able to service our clients at all. And so we've come a long way since then, and I think this broadcast is kind of a testament to that. We're all here remotely, and that's going to be the story of the day. By way of background, as you mentioned, I do specialize in civil litigation. I took a similar road that my friend Sia had taken, and that is I began working at a larger firm downtown, doing civil litigation of sort of a broad, in a broad set of different ways, including commercial litigation, civil litigation, just essentially trying to sort of get myself in court as often as possible and try and advocate for clients. And then at a certain point back in 2015, I utilized that springboard to go off on my own, start my own firm. And since then, I specialize exclusively in personal injury, and personal injury that is sort of bifurcated in the sense that half of my practice, or a little bit more than half of my practice, is devoted to civil litigation. So that's going into the superior court, that's motions, it's jury trials, et cetera, et cetera. The other half of my practice is centered in an area that might be of significant interest to your students, and that is an administrative tribunal. So those are workplace injuries. And that also has obviously oral advocacy, but in a different setting. And so I'd be happy to chat today about kind of how each of those particular streams or forums have adapted to COVID over the past 14 or 15 months, some faster than others, some to greater effect than others, but we'll certainly dive into that today.
Perfect. So let's start kind of with, last week I had the Attorney General on, the Honorable Doug Downey, and he was talking about all the great innovation that's happened as a result of the pandemic, and how does that look like in the context of civil litigation and certainly in terms of criminal law. So maybe we can kind of look at that broadly and how you're approaching your practice in terms of, we'll start with you, Sia, in terms of just even meeting clients, communicating with them. Have we kind of gone away? Do we even need physical office space these days? And what's that process been like in terms of just client relations in wake of the pandemic?
Right. So I'll start, I guess, just to your one of your points about, do we need physical office space? To answer that, much of the procedure that's been carried out, in criminal law has been virtual since the pandemic started, remote appearances. But certainly, I think having a physical office space is still crucial to the practice of law, the business of law, meeting with clients. In my area, it's difficult to have a client meet with you in a coffee shop or in your living room. You certainly don't want that. So attending the office and having that separation from home, I think in the case of many fields, I think it's still crucial to have. In terms of digitization, despite the the many devastating consequences arising from COVID-19, and the pandemic did finally cause the court system, particularly in criminal law and criminal justice, to begin this process of catching up to the, dare I say, 20th century, let alone the 21st century, or late 20th century, let alone the 21st century. We still have things like fax machines, that seem to linger as a mode of communication that has now, been transferred to email, which just sounds shocking right now. But so having different transmission sources is something that we've seen change. You're seeing, voluminous disclosure materials that were previously printed out or burned onto CDs by Crown attorneys, handed over to defense counsel who had to attend at the Crown's desk, now being replaced by cloud-based processes based in a platform of secure delivery where defense counsel can retrieve, download and review. And so what I've found is that this is certainly more resourceful, environmentally friendly, but also easier to access and less time consuming for that retrieval process. And of course, there was always an added cost of labor and whatnot to defense lawyers, who had to bear the cost of photocopying everything. And so that's certainly lessened now as well. So much more progress has been, accomplished in the last 1.5 years or so than has in the last, I would say, 10 years in the practice of criminal law. And so those are all welcome changes. Many of these changes are band-aid, in nature, but others should hopefully be here to stay, but the problem still remains is that, so much reliance still is had on, a paper trail in criminal law, where, clerks who attend the courts still have to, docket and document every appearance, the parties that were present, the type of appearance that it was, what happened, and what's expected, and the next return date of that appearance. So, the date stamps and whatnot. So again, if that's hasn't changed, completely, then we can't expect to fully, gear into a fully digitalized option, so long as we change everything from the sort of the start. I've seen changes. Perhaps I'll let Adrian speak to that if he has anything else to add, and I'll speak about bail perhaps and how the bail courts have been affected by this.
Adrian, so maybe we can look at it from the civil litigation side. So, you don't necessarily have disclosure in the same way from the Crown, but in terms of maybe communication within your side, with the insurance defense side, in terms of exchange of documents. I mean, I had a brief foray there in personal injury, and I would see the stacks and stacks of paper for medical reports and things like that. So maybe you can kind of tell us how that's gone, as well as what we were touched on there as well, in terms of just client relations, communication with client, and using Zoom and other technology to kind of keep in touch with them.
Yeah, so what I'm going to attempt to do is I'm going to attempt to sort of rewind about 15 months ago. Well, let me set the stage first. Just by way of background, again, I practice personal injury, and some people may or may not know what that entails. But effectively, what that means is that I represent people who have been injured in all sorts of different capacities, whether that be in motor vehicle accidents, whether that be in workplace accidents, whether that be falls. I represent people who have even congenital issues and need to access long-term disability through their insurance. So my biggest concern for these individuals always, and generally speaking, I would say about 80 to 85% of my clients have had their ability to earn income interrupted. And that means that their income stream has been interrupted. And that means that more often than not, they're really concerned about how they're going to make ends meet. They're really concerned about how they're going to pay rent. They're concerned about how they're going to, continue to put away money for their kids' school, et cetera. So when the pandemic initially happened, I fielded dozens and dozens and dozens of calls of extraordinarily concerned clients saying, what is going to happen? This process is already incredibly slow. It takes a long time for me to get my day in court. It takes a long time for us to get to a position where we might be able to monetize my injury. So what's going to happen here? And I was very concerned that the delays that we were already encountering were going to become even worse. We're going to persist even more, and it would be years upon years upon years before people would be able to have their day in court. And to be quite honest with you, I was extraordinarily pleased and surprised by how quickly the industry adapted. And this goes to Sia's point, which I think is worth repeating, and that is that we had an antiquated court system. Our court system was very much still stuck in the 1970s, both by way of kind of infrastructure as well as day-to-day practice. If you wanted your judge, even on a routine motion, to have your materials, they would have to call a clerk with a kind of push cart on the 7th floor of a building who may or may not be answering their phone. And they would have to get them to bring it through an elevator system, get it before them. Sometimes they had their materials, sometimes they did not. There was so much lost by way of efficiency in the court system during the pre-COVID period. And again, I'm not talking about this occurring in the 80s, 90s, or 2000s. I'm talking about this occurring in 2019. This was the system. It was very, very technologically inept, quite frankly. And we were forced to adapt, both practitioners and court systems alike. I not only look significantly older than Sia, but I am older than Sia, not by much, but a few years. But, I practice a little bit different. I wasn't as on board with kind of paperless. I still enjoy the tactile experience of paper, but it is wonderfully helpful to be able to literally upload every single document into a cloud-based system for a judge to review, have that automatically paginated just by virtue of it being uploaded, and be able to refer to it just like that, without the necessity or without the worry of, is this even getting before the judge when I'm set to give my oral arguments or whatever the case may be. It has made it much more efficient. So I'm certainly thankful for that. I can tell you that it's also been the case in my administrative tribunal practice, and that's the administrative tribunal that I'm overwhelmingly in front of is the Workplace Safety Insurance Appeals Tribunal. And so that particular tribunal runs every single appeal relating to an injured worker in the province of Ontario. And that can be people who are injured, in North Bay, in extraordinarily remote areas, to people who are injured in the GTA. They administrate all of that. And so it had been very difficult, much like the Superior Court system, to get information to them. And they too have pivoted towards a both remote and cloud-based, which has been tremendously helpful. That being said, John Paul, I know that you're a Jay-Z fan. I would look at this technical innovation as kind of the gift and the curse. We're talking a lot about what is better about our practice, what is more efficient about our practice, what's allowed us to move forward, what's allowed us to become better advocates by virtue of the fact that we can be more efficient in the collection of documentation. But there are some downsides as well, and I'm sure we'll get into those as well.
All right, so let's go back over to Sia there, and we can talk about the bail court and how that's been done remotely, and maybe compare that to what, for those who are not experienced there in criminal law, especially as to what it was before and what's been working, what sort of the pros there and the cons, or as Adrian put it, to quote Jay-Z there, the gifts and the curses with the way bail is being done today.
Right. So often the first encounter that an accused person will have with the court system is, the arrest, and then after that, appear in bail court if they are in fact being held. So early on in the pandemic, early on in March and perhaps April of 2020, we saw an increase in the number of releases of individuals directly from the station. As opposed to being held for show cause or bail hearing requiring sureties, for example. Rarely was the accused person brought into the courthouse. In fact, they weren't at all while they were in custody. And if bail was not addressed immediately from the station, then it was conducted by way of an audio or video link directly from the institution or the jail that they were being held at. So in historically, you would have sureties who would attend to place themselves as supervisors of an individual, and they would have to, for example, sign surety declaration forms that are filled out and handed to the court. We don't obviously have sureties defending in court anymore. So what we would do is we now have surety declaration forms that are filled out or signed electronically. So what we do to ensure that this surety or this father or mother is who they say they are, because again, in the beginning, it was all being conducted by audio. So you couldn't even see who was who in a bail procedure in court. So what we would do is have a surety take a selfie of themselves, send it over, and take a photo of a driver's license or a piece of ID, hold it to their face so that they can prove that selfie is in fact matching the ID itself, and then send it to the lawyer. The lawyer would then send all of that with the surety declaration to the court for that sort of proof that they are who they say they are. Now, sureties also, again, are able to sign releases, once an individual is released on bail in the comforts of their own homes, send it back to the lawyer sends it to the court. Oftentimes you have cases where sureties don't have computers, don't have the ability, or printers cannot, don't have electronic signature capabilities. So counsel would in those cases undertake that, they have reviewed certain documents with the sureties, and of course, as officers of the court, that would be, valid as proof. Now, so we saw, like I said, initially, quite a surge in releases because the pandemic, as we know, affects jails and places where there's, people held in a communal space much more rapidly than those spaces that we luckily have in the comforts of our own home. However, it does, it doesn't go without its perils and pitfalls, this, system of having remote bail hearings. Also early on, as part of the Ontario Court of Justice bail protocol, we had provisions such as special bail hearings that were that put into place for cases for files that were expected to either be, require more time to complete, whether, they were more complex or serious in nature, or because, there's, a number of sureties that had to be examined, which required more time and court time. So what that meant is that we have a push from the Crown's office, and perhaps the administrative JP who's overseeing these, the sort of putting together of these special bail hearings, to schedule these, requiring scheduling time days and days behind schedule, and so that causes further delays, even sometimes weeks before someone who's fundamentally owed a right to a release and bail to be sitting in jail, sitting in custody. Of course, at this time, not proving guilty or anything like that. And of course, we know that this is opposed to their constitutional right to a hearing, in a timely fashion, or as soon as practicable, as the criminal code tells us. So we have individuals languishing in these custodial institutions, and these delays hadn't been addressed, and still frankly haven't been addressed, to sort of figure out a way to ensure that we don't require special bail hearings on more routine offenses or allegations, and so this is something that has to change and has been causing further delay. Whereas back before pandemic, we would attend in person if we address a certain matter, we would see it, through to its completion. So there are often delays in actually, releasing clients from the institution with lagging paperwork from the court to the jail before, when a person's in the prisoner's dock, they're released. Essentially, the paperwork is done right away. The clerks hand it to the officers. Officers, sign it off and release. But now the documents have to be sent back to the jails, and who knows? It could take hours and hours when someone who's due to be released will sometimes even be held until the next day, simply because administrative delays have caused these backlogs. And one further point I'll make is that we often, so once we have a further handle on the pandemic and a return to in-person hearings are fully possible, I envision a sort of a hybrid system where case management matters, set date courts, things where they're just sort of following up the flow of the case, nothing so substantive, can all be done via Zoom remotely. And in cases where bail hearings would mean that someone gets the right to a bail hearing right away, I think those we can keep with bail with Zoom as well. But of course, with a dual option for some to attend in person if they don't have the means, and we'll get to that topic a little bit later, to deal with something in Zoom, to be able to attend in person like the old days. And so having this dual hybrid system, I think, is the way to go forward. But I think in terms of efficiency, Zoom is a welcome treat for the criminal justice system.
I know there's no bail process there on the civil side, but certainly maybe you could look at some of the preliminary steps that go in. Perhaps maybe you can look at if there is a discovery, or even if there is a motion that needs to be made, and kind of how that's progressed on the civil side with the Zoom era.
Yeah, and you're 100% correct, John Paul. On my side, bail and the entitlement to bail is so foundational and fundamental in the criminal law system, because it's essentially the first time where a court has an opportunity to look at an accused and determine whether or not they can have their civil liberties back, their most important civil liberty. So it's an extraordinarily important topic, both from a criminal law standpoint, but a human rights law standpoint as well. And certainly there's nothing that has that level of gravitas in the civil law system, but there are important attendances. And you mentioned the first one, John Paul, and that is an examination for discovery. So an examination for discovery is nothing more. So when one party is injured by another party, they initiate a lawsuit and they say, "Hey, I've been injured either grievously or in whatever capacity. I've been injured as a result of your negligent act." And so the plaintiff, the party bringing the lawsuit, would then sue the defendant, claiming a compensation for a whole host of different areas. And the examination for discovery is the first opportunity for those two parties to actually meet face to face through their lawyers, and their lawyers can then ask the respective parties all of the questions that they can think of over the course of a day that are relevant to this particular lawsuit. It's the backbone of the civil litigation system. And it is one that I haven't done an in-person examination for discovery since COVID started. So my last one was at the beginning of March of 2020. It has transitioned exclusively to this sort of Zoom setting that we're conducting this particular, this webinar on. And that's, again, for better or worse. I can tell you that I personally think it's worse. I can tell you that nothing replaces being in the same room as an individual, whether that be in a court, whether that be in a boardroom, whether that be in an administrative tribunal. When we're talking about advocacy and we're talking about litigation, it brings so much more to the table than just the law. You're talking about things like credibility. You're talking about things like persuasion. You're talking about things like narratives. And many of those things can be communicated over the course of Zoom. but many cannot. And I can tell you that credibility is, it's kind of this mythical unicorn that is consistently chased certainly by criminal defense lawyers, and definitely by plaintiffs' lawyers. You constantly want to exhibit your client as being credible, being worthy of belief, being somebody that their story makes sense. And not only does it make sense, but they elicit sympathy. There's somebody that you can genuinely believe the words that are coming out of their mouth. And I find that this process, Zoom, though it is allowed things like bail hearings or criminal trials or examinations for discovery or civil trials, it's allowed them to go forward in a timely fashion. It's kind of like low def versus high def. So, in Hollywood back in the mid 2000s, there was a whole discussion about kind of converting from low definition to high definition. And, viewers said, it's fantastic. High definition is just like you're there. You can feel that you're in the middle of a movie. And all of that is well and good. So high definition does allow you to be more immersive, much like an in-person. But high definition also had a lot of complaints, and it had complaints by older actors who said, I don't really like looking at my face in high definition. And so, yes, you can feel like you're more immersed, but you're also bringing about all of my warts. And that's the thing about credibility in the context of Zoom. That is that if you have a client who is not the most credible individual, not the most articulate individual, a bit rough around the edges, quite frankly, you prefer to have that client in low definition. You prefer to have that client in a Zoom setting, because how much that client lacks credibility isn't that apparent. But if you bring them in a room and everybody can really see how nervous they are, they can see how much they're twitching, they can see how their eyes are kind of all over the place, they can see their body language, and quite frankly, they can genuinely feel that there's something off here. Then you're happy that you're conducting your examination in Zoom. But when you have that individual who every time you speak to them, your heart really reaches out to them, and they're somebody who you can't wait to get in front of a trier of fact, whether that be a jury, a judge, a vice chair, and you're forced to sort of put them on this platform, which can be so muted and can really mute somebody's true sense and essence, not to get sort of, new agey about it, but it can certainly dull somebody's presence. Then in that regard, we're doing a disservice. And, for me, that might mean that somebody might not get the compensation they deserve necessarily, or they didn't really knock it out of the park the way I think they would have in person. But, in Sia's line of work, the consequences are enormous. When you're talking about whether or not somebody's civil liberties are going to be suspended on the basis of the fact that they came off kind of flat on a Zoom platform, then, that's troubling. That's really worrisome.
Now, see, I'll go back over to you now on something where maybe there isn't as much controversy in terms of what Adrian brought up in terms of the low def versus high def. There, great analogy, but set date courts, right? And certainly there are similar processes in civil, but looking at it in the criminal context, I mean, what if you had a matter in Barrie or Collingwood, and you're situated in the GTA in the downtown core? I mean, that would be 2 hours kind of driving up there, waiting another hour to be called, and then speaking to it for like 45 seconds, and then having to come back and do that again 3 weeks later. Can you maybe tell us how technology has changed that, and how dealing with set date matters now over Zoom has been? And hopefully it's something that's there to come and stay for the next few years and beyond.
Right. So in the criminal context, set date courts early on in the pandemic, we had, early automatic adjournments for case management and set date type of cases of about 10 weeks or so. That was sort of the default time frame that a matter would return, and it was all done by audio. Frankly, we can't ever go back to the old way where counsel and accused would attend almost weekly for non-substantive appearances, where it was merely a tool to maintain disclosure requirements and ensure that cases are following ahead. Accused had to travel long distances, just to your point, Jean Paul, frequently, sit in court, waiting for their matter to be called for hours, only to have their particular matter spoken to for about 5 minutes, and then have an entire day completely wasted. And so this is important because our clients are typically those of low means. We have individuals who otherwise have to take a day off from work, have to adjust or readjust their childcare duties just to attend for 5 to 10 minutes of their actual appearance, really for nothing. So that will change, and that has to change. And we've seen some sort of hope here where we have to be careful as to avoid a Zoom only method, because many of our clients, particularly in the criminal justice system, especially where you have self-represented accused who lack the necessary access to technology, who may suffer from mental health, a variety of things such as mental health, addictions, or other issues that make video appearances very difficult to sort of deal with as well, whether it's lack of stable housing, just something as basic as Wi-Fi connection not being there, and you'd be surprised, but not even having a smartphone. So you see pros and cons to this, but I think to your question about sort of the time saving element, yes, for counsel, for those accused who are represented by counsel have a much easier time now to deal with these sort of set date appearances, set date courts, case management type appearances by essentially appearing in multiple jurisdictions at any given time in one day with ease. I get to do that. I can appear in Guelph, I can appear in London, Ontario, and any court in the GTA on any given day, just if I manage my block of time properly. I would never be able to do that if I'm driving around, which criminal lawyers tend to do very frequently, from one jurisdiction to another, mandatorily to attend these set date appearances that I refer to. And clients would get breached, and this is a criminal charge. Breach of fail to attend court is a breach. And for what? It's just simple things that should not have even been an issue are now corrected. But of course, we have to be careful. So that's why I said, this hybrid system, I think it allows for the other population that can't attend and doesn't have the means to continue to attending in court, and for those who have it, in order to have them sort of apply themselves virtually and remotely. And I just do want to talk about just a few points here that Adrian raised about what it is to have. I guess I'll move on to more substantive matters, trial by Zoom. I think those of us who are tech friendly have a real advantage with Zoom trials. I would never, imagine myself conducting a trial other than an in-person trial ever when I first started practice. But I've really come to embrace sort of this Zoom, and I say Zoom, but any sort of medium, in the right circumstances and with the right case. I think I recently conducted a trial recently where there was a co-accused, counsel, and of course their client and my client. Both clients were in custody, and we were appearing separately from our offices, but it took just forever for the accused to be brought into the video stream in the institution itself. So that caused further delays where you'd think it'd actually be more efficient and more time saving. It was rather the opposite. The judge got frustrated. It was just, it took hours because there was administrative issues and delays with the guards at the jail in terms of just managing who to bring where and even working the system themselves. So there are certain, positives and negatives, but when it comes to trial fairness, as Adrian, indicated, every accused person in a criminal justice context has a right to make a full answer in defense and entitled to a full cross-examination of every Crown witness, right? So there remains the question, such as whether you can even effectively cross-examine a complainant over Zoom, or whether a trier of fact can make a proper assessment of credibility or reliability without seeing the witness in the flesh. I mean, like, those are really important principles here. So these are all difficult questions and must be decided by counsel with the instructions, full instructions from clients, after having been fully informed of the risks and benefits of doing things remotely versus in person. I know Adrian mentioned some of the limitations there in his context, but video testimony often misses or filters out emotional cues, and I know Adrian talked about that as well. Particularly if there are connection delays or communication issues, when counsel are talking over each other, when one's Zoom is delayed, and then everyone's just speaking over each other. Certain things might be missed in court that are so key when it comes down to sort of these very crucial points that you're trying to get out of a witness. The fundamental right to face your accuser, in a criminal proceedings, video might diminish that entirely, and this right to an accused. So exceptions remain, of course, that child witnesses and other witnesses, as per the criminal code, often do appear by video, but for the most part, even in court identification, I know in Adrian's case, sometimes maybe having that grainy appearance might be a benefit, but when it comes to identifying the accused, a witness is identifying my client or trying to, that's going to present its challenges, because in that case, you do want to make sure that the proper identification can be made. What better than to be in person, in the flesh, point, this is the fellow who was at the scene. Whereas if it's by video, there's always potential issues and concerns as to whether they have the means to actually make that proper assessment or not. And finally, another, I would say, pitfall here is that there's that inability to communicate with clients. The very basic task has become so crucially obvious now, where particularly for accused who are in custody, without having to even just have their queue for their lawyer to attend right by their side to tell them something, an observation that they may have had, a question that they may have had, or maybe just a trial strategy, something that they came up with, and they said, what, that actually was wrong, do it this way. I can't do that with my client anymore by Zoom. I could certainly ask the clerk or the judge to put me in a breakout room and hope, but that wastes time. We lose that moment where something so crucial, perhaps even in the middle of my examination, would have been so easy and fluid had I been in person, and had my client, given his right to speak to his lawyer at any given moment, is sort of taken away here as well. So yeah, I'll leave it at that, and then perhaps we can get to some of the benefits of Zoom, trial by Zoom as well. But those are some of the concerns I've had, certainly with at least one trial that I've conducted by Zoom for a client in custody.
So let's maybe look at the benefits there, and as well, maybe aside from making sure your cat filter is off and you've not had your roommate rename your name there to something inappropriate. What are some other the do's and don'ts there? Maybe we can start with you, Adrian, in terms of maybe certainly some of the benefits there. I know you touched on some of the challenges there as well, but what are the do's and don'ts for young counsel or young paralegals, whether it's at a tribunal or even a motion or a civil trial? Of what you found in your experience over the last 16 months?
This somewhat goes back to what I was addressing last time, and that is what's the impact of having people advocate in a little box on a screen where nobody's actually sharing the same space. And I recall this quite vividly. When I was an up and coming lawyer, I would use every opportunity that I could. I worked at a firm that had at the time, about 50 different lawyers, and I would tag along as often as I could, from very seasoned litigators to even younger litigators. I would tag along at motions and interlocutory steps, or mediations, examinations, trials, wherever I had an opportunity to observe a lawyer's style, I took it, because I was sort of searching for my own style as a young advocate. I wanted to find I had my sort of natural kind of This is how I present, but let me see what everybody else is doing. And I can tell you that the spectrum was enormous. The range was huge. You had extraordinarily animated advocates on one hand who, lots of body language, a booming, advocate voice, histrionics, big, large gestures. And then you would have advocates who sat there and, read a piece of paper that was in front of them. And I'm not saying one style is better than the other necessarily, but they're very, very different. What I've noticed about this particular platform in advocacy is that spectrum of differing advocates has shrunk, because you're expected to compose yourself in a certain way in these types of settings. You have to be very respectful, which you always should as a legal professional, of course. But what I mean by that is zero interruptions. Keep your voice relatively down. You don't want to come across as that guy or woman yelling at the camera and getting too heated. It's from my perspective, it's very much sort of limited the style and the differing styles. And I've seen countless lawyers on this platform as well. And in many respects, they're almost indistinguishable one from the next. And that's a problem. That's a real problem, because so much of what advocacy is about is persuasion. And so much of what persuasion is passion. It's narrative, it's social cues. So has there been an advantage by way of efficiency? Of course there has, without a doubt. And it's the next best thing. I mean, I don't want to sit here and say, I'm really unappreciative of what Zoom and remote kind of hearings have brought to the table. I am not. Thank goodness they're here. They have, without it, we would be, years and years delayed in moving forward our clients' cases. So I'm quite grateful for it. But I do foresee, much like Sia, I foresee a hybrid system. And in understanding that a hybrid system is on the horizon, I think it's important and it's integral that we really analyze to what degree do we want to normalize this experiment? To what degree do we want to incorporate it in every case? Should it be just the exceptional cases, ones where individuals are unable to attend in person? Do we want to incorporate it in every case at certain stages? These are the types of questions I think we should be having, even from an efficiency standpoint. I agree with Sia completely, that from an efficiency standpoint, it makes a lot of sense. Instead of Sia going and driving for 3 hours for a 15-minute attendance, it makes a lot of sense for him to log in, get in the queue 10 minutes before his hearing is there, have a brief conversation with counsel, do what he has to do, and then get out. And that allows him to free up the bulk of his day to service other clients. But here's what a 2-hour drive does. If I'm driving 2 hours, pick the destination, whatever. If I'm driving to Barrie, or I'm driving to Huntsville, and I have to conduct an examination for discovery, and I got up at 5 a.m. to get there early enough, and I get there and I conduct the examination for discovery, and even if that examination for discovery only takes me 2 hours, well, I drove 3 hours to get there. Now, what am I going to do once I'm done? I'm not going to log off. I'm not going to say, all right, guys, good to talk to you. Thanks, everybody, for the proceeding. Log off and get back to what I was doing at home. I'm going to talk to the lawyer on the other file. I might go out to lunch with that particular lawyer after the examination is done. I'm definitely going to have a discussion with him or her about what the next steps are going to be. It doesn't end. The attendance doesn't end when you are in person. You're still there. You're in the same space. Both of you might have a long drive ahead of you, and before that long drive, you're going to have a discussion about kind of what's going to happen. You're going to even if you aren't going to have a discussion about what's going to happen in that case, you're going to get to know that individual a lot better. You're going to take, the pains of going through the small talk, and perhaps discover that you have more in common than you otherwise would had that discussion not taken place. And a lot of that has been curtailed as a result of sort of Zoom attendances. It's quick and dirty. It's, I have my attendance. I'm advocating for my client. I'm off to the next one now. You're off to the next one. If you're not off to the next attendance, you're off because you have the benefit of, you want to go upstairs and make a coffee and you're in the comfort of your own home, or you want to get outside because your backyard is calling, whatever it might be. So these are some of the disadvantages that I certainly see. But from an advantages standpoint, it's undoubtedly efficiency. It's undoubtedly the acceptance of technology as far as allowing large amounts of documentation to be there at a click's notice. But it's really not to dwell on the negative, it's the negative that I'm really kind of more cognizant of, because I don't want this to become the norm from a personal standpoint.
Now, see, over to you there, and in terms, maybe you can address some of the points there. But what have you found worked for you in terms of preparing for a trial? I mean, mindful of some of those pitfalls. Obviously, going forward, maybe we have a hybrid approach. Some of those challenges as well, assessing credibility when you see half of somebody and you don't know what's going on in the background. What are some of the do's and don'ts that you found, and certainly the challenges with Zoom trials?
Right. So some of the do's and I think necessities here for counsel lawyers is to, first of all, ensure that you have a stable internet connection, and all your equipment prepared and ready in advance of the hearing, whatever it may be. I think JP, John Paul, you made a joke about it, but make sure you have your natural background, no cat emojis or various different features associated to your name. Dress appropriately. Make sure you're still dressed as if you are in court, because you frankly are in court. Prepare all your exhibits in advance. Bookmark your. Adobe has so many incredible features now where you can electronically bookmark everything, hyperlink your matters, where it becomes almost so much easier for a judge who's receiving and reading it to go through everything. So make sure you know how to do that. Make sure you know how to share your screen on the platform that you're using. But of course, you ensure that you turn off your share screen once you finish, because that could create a whole host of issues as well, and privacy concerns. Multiple monitors help. I find that for any new counselor or paralegals, up and coming, make sure you have the ability to look at multiple screens at the same time. I think that's really helpful. And if your client is in the same room as you, have the independent means to communicate with them privately, and sort of ensure that the court doesn't hear any private conversations that you may have. In terms of back to sort of vantage points, Zoom, it's sort of like I don't know how old you guys are, but the Brady Bunch, in the beginning of the intro, you would have sort of Zoom-like boxes. That's sort of how we are now. So the judge has a vantage point and ability to see literally every facial expression that you make, your client makes. And you have to make sure that you really have your poker face on. Whereas you may not have had to be concerned about that when you were 20 feet away from a judge who's sitting, up higher than you. So don't roll your eyes, don't huff and puff the same way that you would, because you are on the same screen, same size, and everyone's glued to you. Don't forget to just your typical mute and unmute. Don't hesitate to have a witness. And I found this, and I've done this before. Don't hesitate to have a witness show everything that they have in front of them in a cross-examination of a complainant, say, where, back to Adrian's points about credibility and reliability being so fundamental here. Go over, have them, rotate their camera, ensure that they have no extra aids or sort of documents that they pre-scripted whatnot in front of them, so that you ensure that they give accurate depiction of what they said happened on this occasion, for example. So I've actually had asked judges to ask the witness, so it's more respectful, to just ensure that there's no one there, rotate their camera, make sure there's no one else in the room with them when they're giving their testimony, and the judges have very gladly complied. So that's something else that you can sort of consider as well. And I think another benefit I'll point to as well of having Zoom, though, is, there's the absence of video trial options in certain rural or more distant jurisdictions means more accessibility, whereas there would be a denial of justice. So I'm thinking specifically, and again, related to criminal justice, the indigenous communities or indigenous accused who are isolated oftentimes in communities that wouldn't have a proper court system in place, having these hopefully setting up virtual or remote type of institutions there would ensure that they also have access to justice, and they wouldn't have to go to the nearest courthouse miles and miles away, perhaps, to attend court and be in the justice system sort of process. So I think it does have its benefits for remote counties as well. One other area, perhaps Adrian can put his mind to it as well, because I know he would be in front of juries as well, is what do we do about jury trials? Socially distanced jurors. The government has announced that, and the Superior Court of Justice has announced that jury trials will resume, are expected to resume in the fall of this year. I mean, we're talking loads and loads of cases that have just been backlogged, and serious, important cases, for charges, that include murder, perhaps, that have just been backlogged because the accused wants their right to a jury. And so, how will they even look like? I think, will they be concerned about the health? Will jurors be concerned about the health risks of going to court, which will then inhibit their engagement in court? Is that something to consider? Perhaps socially distanced trial raises, fair trial concerns, because it may involve less diverse juries, impeding, effective participation by some versus others, and create barriers to open justice that we need. And the small number of socially distanced trials that will take place will not deal with the backlog of cases that are just waiting to be heard in the system. So, just even thinking of it in a courtroom, do we have courtrooms big enough to address and the social social distancing manner of jurors inside those courtrooms? And if we don't have big enough courtrooms, what are the struggles we have there? And I think these are concerns that we have to deal with. But also, what about jurors? And are we going to have them remotely at home? If so, then just sort of the concerns that we have with respect to ensuring that they maintain focus, but they don't also engage with other features that may poison their role as jurors as well. But I think one of the other features that's important for juries is that they build that network and sort of bond and strength amongst each other. That means they're isolated together. They get to remain in the company of one another for perhaps weeks and weeks. And I think building that connection is important. Whereas if it was a socially distanced trial or hearing, that may be difficult to do so. And so I don't know how it will look like. I do have cases that are scheduled for jury trials in the near future. And frankly, I don't know if they'll be reached, and if so, how they'll pan out. I guess we're all in this together, trying to figure out as we go along.
Perfect. So thanks for both of you for taking the time here and joining us today and sharing all that insight. Perhaps if you have any final words of wisdom, I know you're both big tennis players. I know you maybe use that to kind of get back into the swing of things now that things are opening up. But maybe you can talk a little bit about kind of coping with your own mental health and as well here in terms of any final advice for students. Given that we're on, again, Adrian pointed out the drive, that 2 hours. The other thing there is you're unwinding for 2 hours, as much as you're not just turning it off and you're going back to work. So maybe you can touch on that as well. Any final words of wisdom here for the students listening? And thanks so much for joining. Let's start with you, Adrian.
Thank you, John Paul. I really do appreciate the opportunity here. I'm so pleased that you concluded this discussion on that topic. I have an office of 12 individuals. My office has gone back to work on a staggered basis, essentially since about June of 2020. So I'm typically in the office anywhere from 3 to 4 days a week. Every member of my staff is in there for about 3 to 4 days a week. And so I keep in very close contact with them, both kind of, remotely and physically. And one of the absolute points that every single individual in my office has made, from lawyers to paralegals to law clerks to students who are helping out, to the receptionists, to everybody, is how difficult from a mental health standpoint it has been for them, being a legal professional with all of the stress that comes along with that particular job, the responsibility that comes along with that job, coupled with the isolation and feeling that they're doing it on their own. And I can tell you that I certainly was not spared that existence. Even this particular winter, I found it very, very difficult. I was somebody who had returned to the office in some capacity. I have plenty of outlets personally. I'm in a very privileged position, yet I felt the real grind of isolation and COVID dragging me down from a mental health standpoint considerably. The absolute panacea or cure to that particular ailment is community and relationships. There is nothing, having a discussion, a socially distanced discussion around a boardroom table with my staff, whereby we can look each other in the face, have an actual discussion, pick up a file, share a document, pass it around, strategize, finish doing so for an hour, and then stop doing that and say, hey, how's your mom? How's your wife? How's your husband? How's everything going? That has been instrumental. It's so important to carve out that time, that personal time, the small talk, the jokes, the moments of levity, I feel have really diminished because folks are they're doing what they need to do. They're doing so on these types of platforms, but that personal aspect has really, really suffered. So the degree to which you can certainly engage in that as much as you can, and it can be done virtually as well. I know that there are a number of free platforms out there that allow offices to get together casually, have kind of joint discussions on projects, and then incorporate sort of chat or messenger type aspects to it, where they can also have side discussions that are of a more casual basis going on. I mean, just definitely immerse yourself in the more personal aspects as a professional. And I think that's certainly one of the ways that we can go about, getting through these mental health issues.
Yeah, so many key takeaways there from what Adrian said. I couldn't agree more. As litigators, but specifically in the criminal bar, that network of that courthouse networking, and the ability to interact with others is so fundamental. We're dealing with an adversarial system where, in my case, our clients' livelihoods, human beings' livelihoods, are in your hands. Their backs are against the wall. You're the only person that they have. You need to be healthy. You need to be well, mentally stable, to be able to ensure that you give them the best defense that you possibly can. So having those discussions with counsel, exchanging those war stories, I think are so crucial. The biggest thing I recall being exchanged in a courtroom, lawyers' lounges. So I have this guy, that would be the opening line. I have this client, and then you'd go on, and then they'd give their input. You'd seek advice and counsel from senior lawyers. And I think for young lawyers who are coming out, this we can't, I bet that they're just really just looking to get that uh, human contact once again. And I can't wait to go back and to have that camaraderie, to have that ability to exchange ideas, to feel like there's a sense of belonging in a greater cause here. And absent that, I think it is quite isolating. You do feel alone. That that COVID fatigue does get to you, especially with the very sort of difficult issues and tasks that we have to deal with as litigators. It can be quite huge and massive. So getting back out there, I think it's so important, and ensuring that you do take care of yourself physically, exercise, have time for yourself is fundamental as well. And it's really important. And I'm lucky to have had the ability to do that. As a sole practitioner, I still take advantage of other lawyers in my chambers, and in terms of getting information from them, exchanging ideas from them. And I think that's something that I can't wait to do in a courthouse setting as well going forward.
Perfect. So thanks again for both of you here for joining us. I see a random question here from Tommy. Are the Bucks coming back to win? I know you're both big basketball fans, so maybe just a quick word from you, Adrian. Are the Bucks coming back, or Suns got it?
Suns in 4. Yeah, I think Suns are gonna sweep this out. Bucks have had their day. I think it's Chris Paul's time. He's probably the most deserving player left in the NBA who has yet to win an NBA championship. So I'm rooting for those Phoenix Suns.
So yeah, you get the last word.
Yeah, I think I'm gonna have to go with the Bucks. I am a big Giannis Antetokounmpo fan. He's had a very difficult path to the NBA, and I really know that he has that drive and motivation to win. He's a solid basketball player, and I can't wait to sort of see him truly cherish that NBA trophy.
Perfect. So thanks again for both of you for joining us. Thanks for everyone for tuning in, and to take care and stay safe.
Thank you.
Thank you. Thanks for having us, John Paul.